is Adler and I'm representing the defendant, Phoenix. We are moving for summary judgment in this case to uphold a sacrosanct tenet of corporate law that corporations should not be held liable for the debts and cases against their acquired assets. And I make this argument with three main points. First, that this was a bona fide acquisition where there is no hint or evidence of fraud. Second, the plaintiff has failed to introduce a triable issue of fact into the record. Their declarations merely mirror ours, and there is little for this court to try. And third, questions of policy really dominate here. What kind of precedent does it set for this court to lift the corporate veil in a sense and allow liability for acquired assets?
It isn't really the legal policy with respect to summary judgment. Summary judgment is a disfavored remedy, and instead we should let the facts be developed through the discovery process.
Your Honor, there already has been some limited discovery. We have the declarations on the record, and they've simply failed. The plaintiff has failed to introduce any positive evidence of fraud, any positive evidence that there was a lack of consideration, or that there were individuals in the new corporation such to meet the qualifying law. Summary judgment is disfavored, Your Honor, but when the record is so devoid of evidence to support the claims, this court should move and should grant the summary judgment claim.
But isn't there ambiguity about the way that the cause was valued in this case?
Yes, Your Honor, but the plaintiff has failed to introduce evidence showing that there was actual lack of consideration, because what we see is that the Phoenix actually had no notice. Here today had no notice. The car companies had no notice of this lawsuit when they went ahead and merged, and when Phoenix purchased the assets of Here Today. So there isn't anything in the record to suggest that there was a lack of consideration. That is unrebutted by plaintiff's own investigator.
Wasn't there notice in the sense that Mr. Stills came to Here Today 6 times with his car? Surely that provided some notice to Here Today that he was a dissatisfied customer and highly dissatisfied, and potentially a person that would be bringing a lawsuit.
Perhaps, Your Honor. I think that it's important to remember, though, that at a car dealership there must be thousands of repairs that occur on a periodic basis. And the fact that a car has repeated problems may actually not put a company on notice. I don't think that is enough, given the sparse record, to present a tribal issue of fact here.
All right, keep going.
Sure. I'd like to reference the case of Tenneco in the Ninth Circuit, which held that corporations do not assume the obligations of their acquired assets. This is a fundamental tenet that this court should not preach unless there is evidence in the record showing that the exceptions are met. And those two possible exceptions are, one, that the corporation is a mere continuation. Now, to prove mere continuation, the plaintiff would need to introduce evidence creating a tribal issue of fact showing that there is shared identity between the shareholders, and that there's a lack of consideration. And there's a serious problem in showing that there's a lack of consideration, as I previously mentioned. But in focusing on the shareholders, it's important to note that no California court has held that this exception to the main tenet that corporations do not assume liability based solely on evidence of a similar shareholder identity. Not a single court. So it would be a drastic step for this court to do so, given the paucity of evidence showing that there's something more than just a family member on the boards of both corporations. But
isn't the relationship even closer than that? Frank Sherwood is the majority shareholder in the new company as well as the old company. The new investor is his sister-in-law. We don't know anything about the finances of the brother. How doesn't it seem like there's material issues to fact about the close identity between the old company and the new company?
Your Honor, the law does not call into question the law under Tenneco for articulating these exceptions. Does not bring into question whether there's a relationship between the shareholders. The law simply states, this court case simply states, that there has to be a shared identity between multiple shareholders and individuals on the board. I don't think it's enough. And for the plaintiff to introduce evidence showing that they're family members or that they're related. I think that doesn't meet the bar of presenting a tribal issue of fact here. The last point I'd like to address is really the important policy considerations here. It is essential for the state of California to encourage and to hold strongly that corporations are not liable for the claims against their acquired assets. This is a fundamental tenet of corporations law, and it is crucial for encouraging business investments. We have to think about what kind of precedent would this set if a sparse record could defeat summary judgment on this record. It would actively discourage individuals from starting companies because they would fear that if they acquired a company or purchased assets that they could adopt all of the claims against them. So I think this is something we really should take care before lifting. And if I may also, another area in the record where there is devoid of any evidence whatsoever is the issue of fraud. The defendant, we have introduced evidence, they dispute the existence of fraud, but the plaintiff's own private investigator makes no conclusive statement. There's not even any, beyond drawing an inference based on a car not working, that is the only evidence of fraud. And I think we have to think about the big picture here. Would a company really incorporate another company into theirs? Would a company acquire another just to defraud one individual's car? I think that is just, there is no evidence creating a tribal issue of fact on that matter, and it's for those reasons that summary judgment should be granted.
If I were to rule in your favor and grant the motion for summary judgment, if Mr. Stills in fact was sold a defective car, what is his remedy after I grant the motion?
Your Honor, I'm not entirely sure his remedy. He'd probably be able to either sell the car if he was dissatisfied with it, or pay out of pocket for his own repairs. But the fact is, it's been something almost 6 months of working with us. We have, in good faith, made every repair, tried to help him, but at some point, he waited a little bit too long. The company essentially dissolved, and I think the law doesn't actually account for the circumstances of individuals when it's upholding the corporate veil. That is, it's sort of a sacrosanct part of our law, and so apologies to the plaintiff, but he's sort of exhausted his remedies with here today because they no longer exist.